Members, we've already formed a quorum, so we can start our meeting. Please invite the government officials to come in. Yes, we can start. So welcome, representatives of the government. I won't introduce them one by one. So let's start with the agenda items. The written response from the administration to issues raised at the meeting on the 4th of June. I believe it has already been distributed to members. And today we have received a written reply from the Hong Kong Trustees Association. I'd like to invite the government representatives to take us through paper 1275-02. Deputy Secretary, would you please introduce your reply to us? Mr. Chairman, there are a number of salient points in our reply. First of all, about the proposed statutory control on trustees' exemption clauses. At the last meeting, Mr. Dennis Kwok made another proposal. That is, with reference to the Mandatory Provident Fund Schemes Ordinance, Cap 485, Section 26, we may apply the provision to this bill in relation to the proposed statutory control on trustees' exemption clauses. Let me say something about the background first. During the consultation before the drafting of the bill, we did not just put forth one option to the public for consultation. At that time, we observed that apart from codifying the common law, we noted an exemption clause in Cap 485. So we would like to have a discussion. During the consultation exercise, the Bar Association then said that the provision on pension trust under Cap 485, the Bar was of the view that that modus operandi was not suitable for this particular bill. We went back and considered that, and now it's raised again by Mr. Kwok. During consultation, indeed, there were more respondents who prefer the proposal in the bill in relation to statutory control. Previously, we explained that fraud and willful misconduct and gross negligence are already in the existing provisions. Mr. Dennis Kwok did query if the expression would be problematic. As we mentioned in our past documents, we're of the view that that should be all right. And given the existing operations of the profession, that should be adaptable. So there shouldn't be any problem. And then in relation to Section 6 of the TO, your legal advisor made some comments. We went back and had some deliberation. Your legal advisor asked whether the proposed provision is clear enough. If Section 6 is to be deleted from the third schedule to clarify the provisions so as not to have any misunderstanding, we agree we can do that. So if the Bills Committee so agrees, in accordance with that piece of opinion, we can move a CSA. And then we have to go back to the issue of the proposed abolition of the rule against perpetuities, RAP. Mr. James Toh asked for some information. Through us, we pass the questions to the Hong Kong Trustees Association, the STEP. I understand that the STEP has just submitted a reply. Right from the very beginning, we said that for major cities or jurisdictions under common law that are comparable to us, we can say that we are a forerunner. In terms of competition, we fared better than the UK and Singapore. As regards the proposed abolition of RAP, most cases will involve offshore jurisdictions like Dubai, the Cook Islands, and so forth. In our previous comparisons, we say that in jurisdictions like Australia and different states of the USA, that was already abolished. Well, the feedback of the industry is foreseeable because the RAP, when compared with certain jurisdictions, has the greatest deterrent effect. However, those jurisdictions are different from the UK, so the RAP was already abolished previously. As for Singapore, they changed 80 years to 100 years with restrictions. In Singapore, the competitiveness for trustees' business has not been enhanced. Whether it's 80 years or 100 years, Singapore was only trying to say that it is setting restrictions. As we said, either we abolish RAP or we set a longer restriction period. Whether it is 100 years or 150 years, the message sent to the market is that we're setting restrictions. Then we may be embarking on the old path of Singapore. The feedback from the market will not be good. It will be a negative feedback, hampering our competitiveness. So, Mr. Chairman, that's our overall response. Members, after reading the papers and listening to the response, any special comments? Martin, I have a question. That's about the 20 states of the United States that have abolished RAP. Is New York, California, and Illinois covered? We'll try to obtain the information from the industry, but up to this moment, we've not received any information from them. So if you've got the information please pass it to us as soon as possible because we're concerned about all information related to our status as a financial center. Mr. Leung, I observe that for those jurisdictions who have abolished RAP, including the Cook Islands, Labuan, Jersey, Guernsey, etc., there are more aggressive low-tax regimes. The Cook Islands even has confidentiality laws that prevent regulatory authorities to check the parties behind the scene. Now, these are tax evasion paradises. So if we follow suit, our reputation as an international financial center may be tarnished. Mr. Chairman, you have an answer? Mr. Chairman, I have an answer. Right from the very beginning, we said that we're not trying to compare ourselves with other offshore jurisdictions. We mainly refer to the legal system of the UK and Singapore, which had undergone legal changes in the past 2 decades or so. We must not let people feel that we're a paradise of tax evasion. Our transparency must not be affected, so we may not have to be so aggressive. So some parties may consider us conservative. Some members who've listened to us also said that we shouldn't be that aggressive. At least we must not lose out to the other major international financial centers. On other fronts, can we be forerunners in certain respects? So at the beginning, I explained that this is almost the only area that we can be a forerunner, because if we look around at other international financial centers, they don't yet have this. And the only area here is RAP. And last time when members of the industry were here, we also heard that RAP had nothing to do with tax items or dissemination of information or how much information the beneficiaries would receive. So we're absolutely not comparing ourselves with other offshore jurisdictions. But then for this particular aspect, we can justify ourselves. And this proposal is also practicable. What about New York and Washington? Do they have similar provisions? Martin? It's okay for me. For exemption on gross negligence, it's okay for me. However, 3 acts are covered. Fraud is the first one, right? And then willful misconduct, and then gross negligence. For willful misconduct and fraud, they are quite well defined. It depends on the mens rea of the party concerned. But gross negligence may not be so subjective. Well, there are no major problems. But as the bar has raised this, can we provide a statutory definition? Can you consider that? In accordance with case law, well, I can't remember the case. What is it? There was a case which covers the difference between gross negligence and fraud. So perhaps we should look at the precedents and see if we can work out a statutory definition. Understand that that's the suggestion of the bar. It's not really that necessary, but since it has raised it, can we consider that proposal?
Deputy Secretary. Well, I stated my position last meeting, and I haven't changed. At this stage, I don't think it is appropriate to make such a definition, because we like to have more case laws, to let case laws to develop, so that we have a better context to consider. Because if we just make a proposal at this stage without consulting the industry, the legal sector, and stakeholders, it may be premature. To play safe, if members agree to the principle, we agree that we can review this in the future. All right, it's just a concern. All right, if we are done with the administration's response, we will go back to our clause-by-clause scrutiny. Let's go back to our marked-up copy. Paper 1213/01, page 29. We were up to 41C. So should we continue with 41D? Mr. Yu, please continue. Thank you, Chairman. We were up to 41D, connected duties or linked functions. The trustee has the power to appoint to carry out certain function as the trustee's agent, and if that person is subject to some restrictions, if the original trustee is subject to some restrictions, then the same apply to the trustee's agent. For instance, if a trustee has delegate his power to invest to his agent, then the same advisor on investment has to be consulted. Well, if the trustee's agent is coincidentally the same advisors, then he will not be subject to the same restrictions. 41E, terms of agency. The general principle is the trustee can decide on what terms to employ his agent. However, there are some restrictions. For instance, the agent is not allowed to further authorize another agent, and there also be terms to restrict his liability, or there may be terms to deal with conflict of interest, because these are more important terms. 41E specifies that it's only with good reasons that such terms can be included in the terms of agency. 41F, asset management. If the trustee would like to delegate the function of asset management to another agent, there are some conditions. First, the authorization must be in writing, and secondly, there must be a policy statement to serve as guideline for the agent to exercise this function. And the policy statement has to make clear that it is binding on the agent. And subsection 5 defines what is meant by asset management functions, and they mean the investment of assets, the acquisition of property, and also the management of property. Yes. A short question. Is there any overlap in duty between the asset management functions here and also that in license number 9 of SFC? Would the agent have to be licensed? If yes, is there any interaction between this provision and the regime under SFC? This is made with reference to relevant provision in the UK Act. Asset management here is construed in the general manner, and that would mean investment and acquisition of property. Is not related in particular to the type of asset management under SFO, because the scale of investment here may not be in the scale of those contemplated under SFO. For instance, there is a $1 million, and the agent is, say, expected to purchase securities with that or to deposit into a bank account. So whenever there is any functions related to asset management, this provision applies. Not just professional asset management has to comply with this provision. But 41 capital E and capital F has the word authorized a number of times, but the American spelling is used. Have we considered keeping to the English form of spelling? DOJ, please. Ms. Poon, I think Mr. Tse is referring to the spelling of authorized, whether it should be R-I-Z-E-D or R-I-S-E-D. We do not have any fixed position, but for consistency's sake, if R-I-Z-E-D has been used, then we follow the same spelling. But do we have this policy of keeping to the American or English way of spelling? Perhaps I'm a bit ignorant, but I think in law we still stick to the English mode of spelling. In private correspondences it's okay, but for official documents, is it a point for us to stick to a particular form of spelling? Well, we don't have any fixed position at this moment. Perhaps you should reflect to the relevant authorities in your department. Yes, all right, I'll consider that. Mr. Yu, please continue. Thank you. 41G is about power to appoint nominees. 41G allows the trustee to make a general decision to appoint a nominee. And under this provision, the nomination has to be done in writing. And then this section does not apply to any trust having a custodial trustee. Okay, 41H. It's very similar to 41G on appointing nominees, but here we talk about appointment of custodians. The trustee has the general power to appoint a custodian, and the appointment has to be done in writing, and it does not apply to any trust having a custodian trustee. Right, please go on. 41I. The original bearer investment in bearer invest securities is in question. unless expressly prohibited by the instrument creating the trust, the trustee may invest in bearer securities so long as it is not unauthorized in Schedule 2. And if there is investment in bearer securities, there must be somebody to keep the securities. Unless otherwise instructed, there must be a custodian trustee. And the provision here does not apply to any trust having a custodian trustee. (41J) about persons who may be appointed as nominees or custodians. To be a nominee or custodian, the person must carry on a business that consists of, includes acting as a nominee, or the person is a body corporate that is controlled by the trustees. Because some trustee companies may set up a company to manage the assets. So if the body corporate is controlled by the trustee, then the provision applies. And it would apply to the management of the relevant instruments and assets. And the trustee may appoint trustees of the same trust to be the nominee or custodian. If more than two is appointed, then the two has to act in parallel or jointly. If a person is already the agent of the trustee, there is no prohibition of his being a nominee or custodian. Chairman, Paul, may I backtrack to 41I4? I have some comments. I don't know whether I am right or wrong, but it says
enactment contains a provision that 嗰個 however express 嗰個字咧，會唔會如果擺喺個 provision 之後，然之後
Would it be better if the word express is placed earlier? It's just a minor point. But can you put the two words, however express, put under provision rather than after that? Any views from the draftsmen? Please consider this point. Okay. All right, please jot it down and reply if necessary. Thank you. 41K. Terms of appointment of nominees and custodians. The provisions are just as the same for agents. The trustee may use terms he deems appropriate to appoint nominees or custodians. However, regarding a delegation of duties by nominees or custodians or restriction on the liability of the nominee and custodian, such terms can only be permitted with good reasons. Yes, please go on. And then Division 4. Review of and liability for agents, nominees, and custodians. This is about review of agents and a review of nominees and custodians.
嗰個適用嘅範圍
41L is about application of ensuing sections. If a trustee has exercised functions as an agent or a nominee or a custodian, then the ensuing responsibilities will apply. In the trustee instrument, if it is not specified that the responsibilities will not apply, then the responsibilities will apply to the trustee. What about the next one? 41M is about review of agents. If a trustee has appointed an agent, then he has to review the arrangements of the agent. He has to consider whether it is necessary to exercise his power of intervention. If that's necessary, then he has the duty to intervene with the power of the agent. And then it is provided that if asset management functions are involved, then policy explanations have to be formulated. So the trustee has the duty to consider whether there is a need to revise or replace the policy statement. He has to consider whether the policy statement is there for the trustee to comply. As for the frequency of review, it should be as the circumstances of the trust may require, having regard to the nature of the functions required to be exercised by the agent. 41N is very similar to 41M. 41N is about the review of nominees and custodians, and 41M is about the review of agents. So these two provisions will serve as mutual check and balance. Okay. 41O is to handle the liability for agents, nominees, and custodians. 41O provides that in appointing an agent, nominee, or custodian, a trustee has to discharge his statutory duty of care. Then he will not be liable for any act or omission of the agent, nominee, or custodian. And then if a trustee agrees that the agent can redelegate or subdelegate the trustee's powers or functions, then the trustee is not liable for any act or omission of the delegate if the trustee has discharged the statutory duty of care applicable to a trustee. Okay. 41P is a technical provision. It clarifies that a failure by the trustees to act within the limits of the powers conferred by the law does not invalidate the authorization and the appointment of a person to exercise a function of the trustee as an agent or to act as a nominee or custodian. Of course, if the agent or custodian or nominee acts out of iris, then they have to shoulder their respective liability. All right. Then we move on to remuneration and expenses of the trustees. First of all, Section 41Q is about application of Part 4B. That part applies in respect of services provided to or on behalf of a trust on or after the commencement date of this part, or expenses incurred. Yes, on that day or after. So immediately upon the commencement, yes. Then 41R is about the interpretation of ensuing expressions. A trustee has to act in a professional capacity. So what does that mean? 41R defines that if a profession or business consists of or includes the provision of services in connection with the management or administration of trusts, or a particular aspect of the management or administration of trusts generally or particularly, then that's a profession or business. All right. 41S and 41T handle the issue of remuneration. First of all, 41S is about the remuneration of trustees under the instrument creating the trust. In the past, the common law regime indicates that for a trustee acting in a professional capacity, if the service provided cover services that can be provided by lay trustees, then a trustee who acts in a professional capacity cannot charge a remuneration, just like those trustees acting in a professional capacity. That is, for services that can be provided by lay trustees, here it is provided that a charge can also be levied, but with limitations. That is, there must be a majority support from the other trustees of a charitable trust. You mean the other trustees, consent of the other trustees? Well, usually there will be a certain degree of difficulty. You ask for a majority. They will compete for interests. Well, Mr. Chairman, we are following closely the similar provisions in the UK. This is to ensure that if individual trustees obtain remuneration, well, in fact, all trustees have a certain duty towards the trust. So the trustee must believe that the consent is in the interest of the charitable trust. So we propose this arrangement of support from a majority of the other trustees. This will be sufficient protection for the trustees because we already have provisions for remuneration. We just want to clarify remuneration of isolated cases. All right. 41T is related to the remuneration of trustees other than under the instrument creating the trust. Here we propose that if a trustee has obtained unanimous support from the other trustees, then he can charge a reasonable remuneration. Okay. 41U handles the trustees' expenses. In fact, for a trustee, when he acts on behalf of the trust and incurs certain expenses, the trustee is entitled to be reimbursed from the trust. Okay. 41V handles the remuneration and expenses of agents, nominees, and custodians. Just now I mentioned that the trustee and the agent can formulate certain provisions. If those provisions allow for the receipt of remuneration and the remuneration is reasonable, then the person can be reimbursed. And when an agent provides services and incurs expenses in the exercise of his functions under the trust funds can be used to reimburse the agent or trustee. Okay. Then 41W is related to the liability of the trustee. Perhaps members are clear about the arrangements. This applies to a trustee who acts in a professional capacity and receives remuneration. This provision, the term of a trust must not relieve, release, or exonerate a trustee from liability for a breach of trust arising from the trustee's own fraud, willful misconduct, or gross negligence, or grant the trustee any indemnity against the trust property for the liability. This provision applies to all on the day of the commencement of the bill or afterwards, trust established, and there will be a year's grace period. That is, a year after the commencement of the bill, the trust established before the commencement of the bill will also be covered. So this is something like a year of grace period so that the relevant parties can make suitable arrangements. Members of the industry, what do they think? Will they support this provision? 1 year. That means after a year, all trusts will have to follow the new provisions. That is 1 year after the commencement of the ordinance, all trusts will follow the new provisions. That's correct. For the defense clause, I've already stated my position previously. I won't repeat myself. The latest position of the Bar Association is whether or not the term gross negligence can be clearly defined or a dedicated provision be included to explain that expression. Well, we did provide an answer to that suggestion. At this juncture, for a clear, statutorily valid definition, it's not appropriate. But of course, we won't close the door behind us. The principle is there. In future, if the development warrants a comprehensive provision on this, then members of the industry, the legal profession, and all stakeholders should understand fully the expression. Then it may be appropriate to draw up a definition, but at this juncture, it may not be appropriate. So you're talking about something that may happen many, many years ago. We have to wait for a case to go to court. We'll have to wait for an appeal, etc., etc. Are you not worried that in the interim there are risks? Mr. Chairman, there are two sides to this coin. On the one hand, we've written down these provisions, and there is this worry that the provisions may be lopsided, such that certain parties may be hugely affected, and they may voice their views after they discover they're affected. We don't want to see that. So after balancing all factors concerned, we do think that this provision has already taken care of the present risk. If nothing happens for a long time to come, that means it can operate well.
We will see there are reasons to require us to define it clearly in the bill. Well, the Law Society, the Bar Association has made referred to two cases, and is Midland and also Red Sea Timber. And I would like to put on record that we have already voiced it out so that there can be some guidelines for future litigants and also the court. All right, please put this on record. Thank you. And we continue. 41X, reserve power and transfer of movable property. We have made reference to the Singaporean provision. 41X1 points out that a trust is not invalid only because of the person creating the trust, that is the settlor, reserving to the settlor any or all powers of investment or asset management functions under the trust. And subsection 2, if the settlor has reserved his powers, the a trustee who acts in accordance with the exercise of the power function is not in breach of the trust. 3 and 4 are about the legal effect. If a trust was declared invalid by the court before the commencement day of this amending ordinance, then subsection 1 does not operate to revive the invalid trust on or after that date. However, 41X4 sets out that if the validity of a trust is being questioned, then the court may take into account subsection 1 of 41X in determining the validity. Can the administration explain more clearly subsection 1 of 41X? Because under the law of equity, there is something about the reserving power of the settlor and also the validity of a trust. Here you say that
management 啦，咁即係話其他方面你都係應該跟翻平衡法入邊嘅一啲嘅案例係咪咁樣樣啊？其實係。
I have you consider the relevant case laws. Mr. Leung's understanding is correct. Because the settlor under the common law is allowed to reserve some powers. However, there were case laws. If the settlor reserved all powers, then the court was of the view that it was not really a true trust but a sham. So there is nothing here to influence the court's decision on whether a trust is sham or real. We are only saying that a trust will not be made invalid simply because of the reservation of powers to the settlor. because even under the court, it is not really, it will not be regarded as being invalid by the law, by the court. We have made reference to the Singaporean provision to set it out clearly to give the settler more confidence. This so-called asset management functions. Do you have any case law to define asset management functions? If it is interpreted using general commercial principles, then the settlor can reserve a lot of powers for himself. So do you have any view as to what is meant by asset management functions? I'd like to have on the record your interpretation of asset management functions. We do not have a definition for asset management functions. We note also that in the Singaporean provision, there is no definition as well. But in the general sense, asset management functions means investment of the asset and also disposition of property or under the trust. For instance, the sale and purchase of shares under the trust. Well, please consider giving a definition for asset management functions in the future. Please note this. Okay, Paul. 41X4. I'd like to know whether there is any retrospective effect, because it seems to be saying then for a trust that has never been declared invalid by the court, if there is any problem with asset management, it will not be problematic in the future. You're reflecting the common law situation, and you may be grandfathering all the trusts established before. We are very cautious here. Subsection 3 in particular, we do not want any invalid trusts to be made valid because of this section. However, it is our understanding that 41X1, reservation of powers of investment or asset management functions of the settler, this is in line with common law principles. Now, if a trust is invalid, it will not be made valid because of 41X1. If the simple fact is preservation of powers of investment or asset management functions by the settler, it will not have any substantive influence on the decision of the court. That is, subsection 1 would not make an invalid trust valid. Is that right? Of course, we are not just thinking of 41X1 because it's but one consideration. But if there are trusts that have been in existence for a long time before the commencement of the ordinance, if not for the amendment bill, the fact that the settler has reserving powers may be one of the reasons for making that trust invalid. But 41X1 may remove this consideration. Well, if there are a number of reasons and 41.1 is but one consideration, then the effect of subsection 1 is saying that the trust will not be invalid simply because of this. 41, the court can consider the effect of 41X1, but if there are other factors, the court can still declare the trust invalid. But 41X4 has removed that consideration or that factor retrospectively. In the future, this cannot be a factor for consideration. Mr. Yu? Mr. Yu, can you please supplement? We still believe that the common law is clear. The reservation of powers of investment or asset management functions by the settler would not make a trust invalid. We have not changed the common law position or principle, and therefore we believe it applies to existing trusts. But Mr. Jie refers to a host of factors where it depends on the relative weighting of the different factors. Will the court think that this is the most important factor and change its decision? Our understanding is not, because it is our understanding that reserving the settler's powers of investment or asset management functions will not make a trust invalid. I just want to know whether there is any retrospective effect. Now, if 41X4 doesn't make a difference, why do you want to have subsection 4 here? Unless you want to provide a retrospective effect. Well, as I said, we have not changed the common law position. The intention is to increase the confidence of settlers. Without 41X4, we can say that the provision only applies to newly established trusts. So only settlers of these trusts will be convinced. Existing trusts will not benefit from the effect of this provision. What about cases pending in court? The court may wait for a while. Not just pending cases. All trusts established in the past will benefit from 41X4. I'd like to know whether you want to remove the uncertainty to increase the confidence of settlers. So will you say that subsection 4 actually has retrospective effect, but for the sake of certainty or to increase the confidence of settlers, you're willing to give that retrospective effect? Yes. Okay, if there are no further comments, please go on. 41Y. Transfer of movable property not affected by foreign law of inheritance. We have made reference to a similar provision in Singapore. If a trust is expressed to be governed by Hong Kong law, and if all trustees in the trust are ordinary residents of Hong Kong, on the body corporate or the body corporate, the central management and control of which is in Hong Kong, then this transfer of movable property will not be affected by foreign law of inheritance. This targets anti-force rule. Because in places with civil law, continental law, if a person has passed away, at least part of his estate will have to be transferred to either his wife or children. If before the person passed away, he has put his property in a trust, then in a continental law jurisdiction, the validity of this transfer might be challenged. The transfer may be rendered invalid, so that the transferred property will go back to the estate for distribution to the deceased's wife or children.
We actually referred to the Singaporean system. A trustee established in Hong Kong, its effectiveness will not be affected, and so Hong Kong's attraction as a jurisdiction for setting up of trustees will not be undermined. In Singapore, the trustee must be set up during the lifetime of the settler, and only movable property is included. For immovable property, it depends on the laws of the jurisdiction where the immovable property is located. So this provision will not cover immovable property. All right, it's very clear. Two different periods during the lifetime as well as movable property. 41 big Y, 1B, Roman letter 2. If a Hong Kong subsidiary of a foreign trust corporation, will this exemption be problematic, given that the body corporate is the central management and control in Hong Kong? If it is a wholly owned subsidiary of an overseas body corporate, then will you consider that trust to be in Hong Kong? Mr. Chairman, it depends on the genuine trustee as a body corporate and where the central management and control is. In terms of taxation laws, a number of factors have to be considered. One major factor is that this body corporate, where did its directors make the decision? Take, for example, the directors of the body corporate make the decision in Hong Kong. The parent company may be overseas, but the directors make the decisions in Hong Kong, and it will satisfy the requirement for central management and control. Well, for a body corporate in Hong Kong, I understand, but if you say a body corporate, the central management and control is in Hong Kong, will there be any ambiguity as to the meaning of this expression? Mr. Chairman, we considered that the place of incorporation may be different from the place of central management and control. The policy objective is to make trustees based in Hong Kong to benefit. So this expression is very commonly seen. We mention central management and control in Hong Kong. So trustee companies with their central management and control in Hong Kong will benefit, even though their parent companies may not be in Hong Kong. Will the policy objective be totally protected under this expression? Will there be any loopholes? What about 1A? Well, 1A is related to Hong Kong laws. Well, we don't just look at the place of incorporation, but the place of central management and control. So I'm a bit worried. Are the two expressions equivalent? Mr. Chairman, even if the company is incorporated overseas, if its central management and control is in Hong Kong, it will benefit from this provision. We made reference to the Inland Revenue Ordinance and the provisions for such companies. Under the IRO, in terms of tax return, such companies have been operating effectively. So we use this expression of central management and control. We do have a lot of cases in which a body corporate has a central management and control in Hong Kong. So a body corporate with central management and control in Hong Kong should benefit. That's your intention. Yes. What if a Hong Kong company has a central office outside Hong Kong? There's an operation office in Hong Kong, but the genuine head office is outside Hong Kong. Will it fall outside of this provision? Yes, because we focus on central management and control. It's very simple to set up a company in Hong Kong. We don't want to have totally overseas trustee companies to just set up an office in Hong Kong before they can benefit. We don't want to be that simple. So they focus on central management and control in Hong Kong. Do you have any idea of the proportion of such companies in Hong Kong? Is this provision tight enough? Mr. Chairman, we refer to the IRO when we use this expression, central management and control. The IRO is sufficient in handling such cases. Kenneth, just now the Bureau said that it didn't want an overseas company to just set up an office in Hong Kong before it can benefit from this provision. So my question is, why don't you cover all those companies registered in Hong Kong and all those bodies corporate with central management and control in Hong Kong? Nothing bad in that. If you look at the mode of asset management, many companies would like to register a company overseas and then their personnel and infrastructure are in Hong Kong. Conversely speaking, if you set up a company in Hong Kong and to run asset management in Cayman Islands, for example, well, such cases are very rare. If you want to cover more companies so as to attract more business opportunities, then why don't you include all bodies corporate in Hong Kong? On top of those companies with central management and control in Hong Kong? Deputy Secretary? What do you mean we add another condition, that is, apart from a body corporate with central management and control in Hong Kong, any body corporate with an office in Hong Kong should be covered? Well, you say there may be a company set up in Hong Kong with major operation overseas. Well, for example, in Asia, I find such cases very rare. It's really unimaginable. Rather, in Cayman Islands, Bermuda, etc., 99% of the companies set up there have their central management and control in Hong Kong. Well, you say just setting up an office in Hong Kong may not mean big business. But if you want more business opportunities for Hong Kong, then you should attract more companies to Hong Kong. If you want them to find 41Y helpful or useful, why not a body corporate in Hong Kong, registered in Hong Kong? Anything bad in that? Any adverse impact? According to our explanation just now, if we just add or with another arm to allow such companies in, we may be diluting, in our opinion, the effect of this provision. Previously, some members asked whether such companies will actually employ people in Hong Kong. If a company has a central management and control in Hong Kong, it has to have secretariat support in Hong Kong. So if you say just a company registered in Hong Kong, then as Mr. Yu explained, the effect of this provision will be diluted. Well, Mr. Chairman, even if you have this restriction of central management and control, given what really happened in the past, given the cases we had in the past, even with not that many activities in Hong Kong, the central management and control of a company can be in Hong Kong. Say if the board of directors holds its meetings in Hong Kong, decisions at the higher level are made in Hong Kong, where they may just hold 2 or 3 meetings a year in Hong Kong to make major decisions. Then you have to consider it a body corporate with central management and control in Hong Kong. Of course, day-to-day routines can be done outside Hong Kong. If you want to lift your requirements, you can say a body corporate which carries its business in Hong Kong. That's my suggestion. So I just want to know what you really want to do with this expression. Deputy Secretary, any supplement? Well, Mr. Chairman, we don't aim at covering everything here. We're talking about major functions. We want professionalization. We want business opportunities. So we want the major tasks to be carried out in Hong Kong. Of course, the honourable member has his own views. But we'd like to air our views also. We're listening to members. All right, that means you have listened to that viewpoint, but for the moment you don't want to make a change. Mr. Kwok? Let me cite an example. Many companies set up in Hong Kong are to control a joint venture on the mainland. The shareholders and directors of the company are all mainlanders. Their board meetings are all held on the mainland. This company is to grasp investment projects on the mainland. We have many such cases at the moment. Many joint venture litigations take place in Hong Kong, but the operations are outside Hong Kong. From the viewpoint of creating a better business environment, we should attract more overseas companies to invest in Hong Kong, to use Hong Kong as an investment vehicle. Do you want them to benefit from 41Y? Do these companies benefit from 41Y? What's your policy? In fact, you should want to attract more people to come to Hong Kong to set up trusts and companies. So you should attract more people to come to Hong Kong to set up companies, to use our accountancy services and legal services, or other professional services. So why not let them benefit from 41Y as well? Would that be an advantage? Would it be in compliance with your policy? I think that's what Mr. Leung said.
And we talk about management of asset on the mainland. Well, it depends on the balance. If we expand to cover all companies incorporated in Hong Kong, the effect may be more companies will be incorporated in Hong Kong, and yet other things are all outside Hong Kong, and Hong Kong can only benefit from the incorporation of the company and also the business opportunities associated with its incorporation. We believe the benefits are limited because we believe the most attractive part of our law is for the central management of the trustee to be in Hong Kong if it is a body corporate, so that it is more likely for the trustees and the custodian to bring the asset to Hong Kong. The policy objective of the bill is to encourage the setting up of trusts in Hong Kong and for more trust asset to be managed in Hong Kong. If we just encourage the incorporation of a company in Hong Kong, there may not need to be any transfer of property. Yes, the incorporation of companies in Hong Kong may give us some benefits, but that is not the main objective of the bill. We want more assets and trusts to come to Hong Kong. Incorporation of companies, of course, there are improvement measures in the company's ordinance and by the company's registry to attract companies. What are the downside of opening it up? Well, without the amendment, perhaps because the central management has to be in Hong Kong, the asset may come to Hong Kong as well. If all we require is the incorporation of a company in Hong Kong, then the asset need not be brought to Hong Kong, and this may affect the trustees' decision to transfer asset to Hong Kong. Mr. Jie? As if we follow the suggestion of Mr. Kenneth Leung and use and instead of or, there is no harm in doing that. Now, if there is only the word or, then perhaps you are worried that the only benefits will be associated with the incorporation of the company. But if you add the word and, it's harmless. And any litigation in relation to any asset management will benefit Hong Kong, at least beneficial to the legal sector. And relevant litigations and adjudications would very probably take place in Hong Kong if the company is incorporated in Hong Kong as well. A similar issue? Yes, I just like to add a small point. 1A, it says that the trust has to be governed by Hong Kong law, and if the company is incorporated in Hong Kong as well, then very naturally, if you have confidence in Hong Kong's infrastructure, it's impossible for you to assume that people can set up an incorporation here and then go to Cayman and employ 10 odd persons to run the asset for it. So if it is the trust is governed by Hong Kong law, and then you should also benefit companies that are incorporated in Hong Kong. I think this should be done. It appears that a few members have this inclination, but you haven't convinced us with the possible side effect or downside of this proposal. Well, yes, before the meeting, we heard those comments. So you just note their comments first, and you will think about them later. Okay, please go on. 41Y, and after that, we have some drafting amendments. For instance, 42, the title was Appointment of New Trustees. Now we divide in, we put it under Division 1. And then Division 2, vesting orders. And before 56, Division 3, jurisdiction to make other order, and before 62, Division 4, payment into court. The titles do not have any legal effect. Page 53, amendment to Section 77. For the trust company, is required to deposit $1.5 million with the Director of Accounting Services. They are usually done in the form of deposits in bank or undertaking. So we've made it clear here that a company is required to deposit in the name of the Director of Accounting Services with an authorized institution a sum not less than $1.5 million. So we've just put down what is already in operation. Yes. And because of this amendment, now, because it is clearly set out here that it has to be a deposit, there will be CSAs to replace words such as investment with deposit. The word investment or invest will not be used anymore. And then we have new 100, Section 100. It's transitional in nature. 110 is in Schedule 4, the fourth schedule. The fourth schedule there are 4 transitional provisions on page 60. There will be amendments to 8. 8 is moved to 40I. 23 will be moved to 41H. Will give the power of the trustee to appoint a custodian. And Section 25 we've also called 41B to deal with the nomination of agents and also other provisions to appoint nominees and custodians. If custodians or agents have been appointed in the past with the commencement of the bill, those persons would be deemed to be appointed under the new provisions. And then 4 points out that this bill will not affect the legality of acts made by persons before the commencement of the bill. Please go on. If there are no questions, we have one more schedule, page 56. The second schedule. Now, if there are no other restrictions in the trust document, then the investment items under the second schedule has to be followed. And we have made 2 amendments for investment in stocks and shares. In the past, the listed capital of the company concerned should be no less than $10 billion. We will now tune it down. And for loans in the past, or dividends in the past, there must be dividends paid for 5 years in a row in cash. But it's reflected that even for very financially very sound companies, they may not give out cash dividends every year. So we have proposed to relax it. That is, in any 3 years out of the 5 years immediately preceding the calendar year, and it can be made in dividend or in cash or in kind. And we've also added 7A. The investment products allowed will not include any structured product as defined by Section 1A. So this is 7A. So for paragraphs 1, 2, 4, 5, 6, 7, they will be amended so that they will be subject to paragraph 7A. Please go on. We've done the third schedule, and we talked about statutory duty of care, and then we also cover fourth schedule, and then we will go on to page 62. There is a drafting amendment. Page 66. We have added part 1 and 2 this, and then there is also reference to the 2013 amending ordinance. And Section 3 deals with the application. The bill is so designed that while the abolition of RAP will apply to all trusts established after the commencement of the bill, and all the relevant provisions will be put in Part 2 of the bill. So we will have Part 2, provisions applicable to instruments taking effect on or after commencement date of the amending ordinance. For the existing provisions, because they still apply to existing trusts, so they will be grouped together and put under Part 3. So trusts established before the commencement of the bill should refer to Part 3 to be sure of the provisions applicable. And for trusts established after the commencement date, Part 2 applies. And they will not be subject to RAP anymore. And then we will have new rules applicable to new trusts, and they can be found in Part 2. 3 capital A. Rules against perpetuities, etc. have no effect on provisions applicable to instruments taking effect on or after commencement date of the 2013 amending ordinance. So RAP and restriction accumulations for charitable trusts will not apply anymore unless otherwise specified in the trust instrument. Otherwise, the trust can be perpetual. (3B) When we abolish the rule against excessive accumulations, because of the special nature of charitable trusts, we propose to keep certain restrictions on such trusts. And the period is 21 years. If the trust has the duty to accumulate assets, it can only be kept for at most 21 years.
That is, the funds must be used for the designated purposes of the charitable trust. And then 3C is a technical provision. In previous discussion, it was mentioned that we do have trust for non-charitable purposes. Take for tax purposes, for pets, and so forth. So we do allow for non-charitable purpose trusts to be set up. Now these are special trusts. Under the common law, there are already rules and regulations to restrict the duration of such trusts. So 3C tries to spell out very clearly that perpetual non-charitable purpose trusts will still be under this part because the duration cannot exceed 21 years. So this part does not affect any rule of law that limits the duration of non-charitable purpose trusts. Yes, please continue. Mr. Chairman. On page 70, we have a drafting change in relation to the provisions applicable to instruments taking effect before the commencement date of 2013 amending ordinance. So part 3 is added here. And as a result of this change, there are consequential amendments. For example, in the original 13, there is this expression after the commencement of this ordinance. Now we amend it to read on or after the 13th of March 1970. And before that commencement will become before that date. And then in 16, ordinance should read part. And then accumulations will read division to accumulations. And the commencement date in 18 will be before on or after the 13th of March 1970, replacing before or after the commencement of this ordinance. Yes, Chairman. The last provision to be amended is related to the enduring powers of attorney ordinance. What we would like to handle here is like this. For subdelegation of the trustee's power, we would like to put it under the enduring powers of attorney ordinance. After the commencement of this bill, under the enduring powers of attorney ordinance, execute or exercise or any of the trust powers or discretions should be amended. So we will delete section 8, bracket 3, bracket A of that ordinance. That is, in future, the delegation of trust powers or discretions cannot be done under the enduring powers of attorney ordinance. Rather, such delegation should come under the trust law ordinance. And then we propose to add a section 20 to handle transitional matters. The provision is like this. if before the commencement date, the enduring power already takes effect, then it will be just like what happens before the repeal of Section 83A. That is, the repealed Section 83A continues to apply to an enduring power of attorney created before the commencement date. But afterwards, the relevant provisions of trust law ordinance should be invoked. And then there are consequential amendments for 3G, Section 5(3)(g). We have to delete to exercise any of the donor's powers as a trustee. That's on page 77. And also the table applicable to the trustee, that is on page 78. Under enduring powers of attorney prescribed form regulation, Section 2 of Schedule 1 should be deleted. For Form 2, the citing of the trustee under Section 2 should also be deleted. That's on page 82. I think that's all, Mr. Chairman. Another one on page 89 under Schedule 2, Form 2. Section 2 should also be deleted. All right, so we have finished with clause-by-clause scrutiny. Some issues were raised just now. You will submit further papers at the next meeting. Mr. Kwok made some comments which have already been recorded. Will you move any CSA? Would you move any CSA? It depends on the response of the Bureau. For the time being, I don't have that intention. Well, government, you can decide whether or not you move a CSA to that effect. Well, Mr. Chairman, we undertook to go back and consider certain outstanding issues, so we'll do that. Legal advisor, you have something to say? Now, let's look at the time frame here. On the 18th of June, we'll have another meeting. Before the 18th of June, would you be able to prepare a paper on the outstanding issues? Before the 18th of June. And you already said that you would move some CSAs. Yes, before the next meeting, we'll submit further papers to you on the outstanding issues. Please also submit the CSAs before the 18th of June, such that on the 18th of June, we'll go through the CSAs as well. Then we'll have a final discussion. Well, let me suggest the following timetable. We'd like to resolve this amendment bill within this session. So, on the 17th of June, we'll have the second reading resumption debate. Therefore, on the 2nd of July, the administration has to notify the House Committee Chairman. Then I, in the capacity of Chairman of the Bills Committee, will submit a report to the House Committee. So 2nd of July, administration to put up its request to the House Committee Chairman, and then on the 5th of July, I'll submit my report to the House Committee. Then on the 8th of July, we'll have the deadline for notice to be given by members or the administration in relation to CSAs. And then on the 8th of July, we'll have the second reading that will be the deadline for giving notice for second reading resumption debate. So, our next meeting will be held on the 18th of June at 2:30 p.m. I hope that we can resolve the whole bill on that day. Clash with other meetings? Well, if we have a quorum, well, you can go between